Welcome to the study guide for the New York Life Accident and Health Exam. A firm grasp of New York's insurance regulations separates a confident producer from one who runs afoul of the law on day one. In this video, we'll cover insurance regulation, including producer licensing requirements, agency law basics, unfair trade practices, insurance fraud prevention, insurer solvency regulation. Our website offers completely free exam guides and practice questions designed to help you ace your New York Life Accident and Health Exam. There's no cost, no catch, just solid preparation. So click the link in the description below, get started today, and remember, study smarter, not harder to pass with confidence. So let's get started. Let's start with licensing because everything builds on it. Before New York lets you sell life, accident, and health insurance, you must clear a few hurdles. You have to be at least 18, complete any required pre-licensing study, and prove your competence by passing the written examination. New York wants only qualified people making these promises. Once you pass, you submit your application through the National Insurance Producer Registry called NIPR and pay the fee. But here's what students overlook. The superintendent still must find you trustworthy and competent. They review your background, and a trouble in history can get your application refused under Section 2110, even after you pass the test. So, what disqualifies you? Lock this in because it's heavily tested. The recurring disqualifiers are a felony involving dishonesty or breach of trust, fraud or material misrepresentation on your application, general untrustworthiness, and cheating on the licensing exam itself. Notice the thread running through every one of them. Dishonesty. New York won't license someone who lies. Here's a related must-know. That felony disqualifier ties to a federal law, Section 1033. Anyone convicted of a crime of dishonesty is barred from insurance work unless they first obtain a 1033 waiver, the superintendent's written consent. Without it, working in insurance is a federal crime punishable by up to 5 years. Your license also states your lines of authority, the specific types of insurance you may transact. For this exam, that's life, which includes annuities and accident and health. Here's a rule to burn in. You must never transact a line not shown on your license. Doing so counts as acting without a license for that line. Now, does everyone who touches a sale need a license? No, and this trips people up. Purely clerical or administrative work doesn't. A salaried employee can do data entry, schedule appointments, or take an application the customer already chose. The line is crossed only when they urge a product, advise on terms, or close the sale. This leads to a favorite testable detail, the referral safe harbor. An unlicensed person may refer a prospect and even collect a fee, but only under two conditions. The fee can't depend on whether a sale happens, and they can't discuss any policy's terms. I remember it as fixed and quiet, fixed fee, quiet on terms. What we just covered is exactly the kind of material in our free practice question bank, and these aren't basic recall questions. They're built to test the deep applied understanding the real New York exam demands, with the same tricky distinctions between who needs a license and who doesn't. Go try a few after this. Now let's talk authority, because it explains when an insurer gets bound by what its agent does. A producer's power flows from the law of agency, and there are three kinds to know. The first is express authority, simply what's written in the agency contract, like permission to bind coverage up to a stated dollar limit. The second is implied authority. It isn't written down, but it's reasonably necessary to carry out that express authority. Think renting an office, hiring staff, or using the insurer's forms. Nobody wrote a rule saying the agent may rent office space, but you can't run the agency without it, so the authority is implied. The third is apparent authority, and honestly, this is where students lose the most points. It's created by the insurer's own conduct. If the insurer lets an agent use its letterhead, forms, and supplies, a reasonable client believes that agent can act for the company even if it never actually granted that power. Watch for it. One more idea flows from this. Because the agent represents the insurer, the agent's knowledge is generally imputed to the insurer. So if a client mentions a material fact to the agent during the application, the company is charged with knowing it too, even if the agent never passed it along. This surfaces constantly in claims disputes. Let's move to appointment and termination, the formal link between a producer and an insurer. An insurer appoints an agent under Section 2112, authorizing that agent to represent it. You can hold a license without an appointment but can't place a given insurer's business until appointed, and brokers aren't appointed because a broker represents the insured. Now, when an appointment ends, whether the insurer terminates it or the agent resigns, notification rules apply. The insurer files a termination statement with the department within 30 days, then sends the agent a copy within 15 days after. If the termination was for cause, the statement must include the reason. 30 days, then 15. Why would an insurer ever state that reason honestly, risking a defamation suit? Because the law protects candor. An insurer that honestly reports the reason for a for-cause termination is immune from a defamation suit unless it acted with fraud, bad faith, or actual malice. This exists so bad actors can't quietly slip to another company undetected. Picture this, because the exam loves it. An insurer discovers an agent forged a client's signature and terminates for cause. It files within 30 days, names the forgery, and copies the agent within 15 days. The agent sues for defamation. Who wins? The insurer, because it reported honestly and without malice. The immunity holds firm. Here's a distinction examiners exploit. Section 2112 is about the appointment, the link between agent and insurer. A separate rule, Section 2109, is about the person, granting temporary licenses when a producer dies or is disabled. Don't blow them. 30 and 15 days means termination. 15 months means a temporary license. I know we're moving through a lot of rules, and you might wonder how to make these deadlines stick. That's exactly why I built those free practice questions. They'll drill you on the 30-day and 15-day timelines until you answer without thinking. Working problems is how these numbers move into long-term memory, so please use them. Now this is where it gets interesting. Unfair trade practices. New York gathers these prohibited acts under Article 24, and the exam can test any by name. These are things a producer or insurer may not do to compete unfairly or deceive the public. Let's walk the big ones because they generate a ton of questions. Start with misrepresentation and twisting. Misrepresentation is making false statements about a policy's terms, dividends, or the insurer's condition. Twisting is a misleading comparison used to push a policy replacement. Then there's false advertising, misleading illustrations, and defamation, meaning untrue statements attacking an insurer's financial condition. Each is a lie aimed at someone. Next come three that travel together, the C and R trio. Coercion is forcing someone to buy insurance from a particular source, like a lender requiring you use its own agency. Intimidation uses threats to restrain or monopolize the business. Boycott is refusing to deal or agreeing to refuse to squeeze out competition. Now, the heavily tested pair, discrimination and rebating. Unfair discrimination means treating people in the same class and equal risk differently or using a prohibited basis like race, creed, or national origin. The key phrase is same class, equal risk. If two applicants truly sit in one risk class, the insurer can't charge them differently. Let me make that concrete. An insurer charges a 55-year-old more than a 35-year-old for the same life policy. Discrimination? No, it's permissible because age is an actuarially justified difference, so they're in different classes. But charging two identical 40-year-old non-smokers different rates over national origin? That's unfair discrimination, same class, prohibited basis. Rebating is the other half, and a classic trap. A rebate is offering value not specified in the policy to induce a sale. The textbook case, a producer offering to refund half the first-year commission. That's illegal, and here's what students miss. Both sides can be penalized, the one who offers and the one who knowingly accepts. But not every gift is a rebate, so know the exceptions. A branded umbrella or calendar worth $25 or less is fine. That's the de minimis rule. A dividend on a participating whole life policy is fine because it's specified in the policy, and returning unearned premium is fine too. None are illegal inducements. One more practice belongs here: mishandling premiums. A producer must never misappropriate, convert, or illegally withhold them. If you collect a premium and fail to remit it to the insurer or fail to return unearned premium to the insured, that's conversion, a ground for license revocation and possibly a crime. Keep client money separate. Here's my shortcut for exam day. For discrimination, ask same class, equal risk, treated differently on a prohibited basis. If yes, it's unfair. For rebating, ask, is value changing hands that the policy doesn't specify? If yes, it's a rebate unless it's the $25 gift, a dividend, or returned premium. If these legal versus illegal distinctions feel challenging right now, don't worry, that's completely normal. It's exactly why I created that practice question bank. Working through rebating and discrimination problems, seeing the same traps in different disguises is what finally makes it click. Those questions are free and waiting for you in the description. Let's shift to how New York polices all this daily. The superintendent doesn't just wait for complaints. The department runs market conduct examinations. It can inspect the books, records, accounts, and business practices of any licensee at any reasonable time. And here's what matters: refusing to permit an examination is itself a violation. Cooperation is not optional. That cooperation has concrete pieces. Under Regulation 152, policy and claim records are retained 6 years, or until after the next examination report, whichever is longer. Insurers also keep a complaint log and answer complaints the department forwards. And when the department asks about a claim, you have 10 business days to respond. Now, insurance fraud, a top priority for New York regulators. The Insurance Frauds Prevention Act rests on 3 pillars. The first is the definition. A fraudulent insurance act is knowingly filing or helping file an application or claim with materially false information or concealing material facts with intent to defraud. That's the core. That act carries teeth. It's a crime graded by the amount involved, and it also carries a civil penalty of up to $5,000 plus the amount of the claim per violation. The second pillar is the fraud warning. Every application and claim form must display a conspicuous warning that filing false information is a crime. The third pillar is mandatory reporting. Any licensee who has reason to believe a transaction appears fraudulent must report it to the department's Insurance Frauds Bureau within 30 days. Reports made in good faith receive immunity from civil liability. Remember, the Frauds Bureau is a law enforcement unit inside the department itself. Here's a scenario. A claims adjuster notices a disability claimant's medical records look altered and the income figures don't match payroll data. The adjuster reasonably believes the claim appears fraudulent. What now? Report to the Insurance Frauds Bureau within 30 days of forming that belief. Made in good faith, the report is immunized. Now, privacy, where the nuance separates strong students from average ones. Regulation 169 treats financial and health information differently. Non-public financial information may be shared with unaffiliated third parties, but only after giving the consumer a reasonable opportunity to opt out. Health information is stricter. It can't be shared without the consumer's authorization. Hold it this way. Financial information uses an opt-out model. The consumer gets a chance to say no. Health information uses an opt-in model. The consumer must affirmatively say yes. Both require an initial notice, then an angel one. And the trap? Opt-out is a reasonable opportunity, not a fixed 30-day clock. Here are the numbers examiners love. A fraud warning on every application and claim form. $5,000 plus the claim as the civil penalty. 30 days to report suspected fraud to the Frauds Bureau. And for privacy, financial is opt-out, health is opt-in. Rattle those off coal for easy points. Remember, mastering this takes real practice, not just watching. The free practice questions help you turn what you're learning into exam-ready reflexes. When a question hits you with financial versus health privacy under pressure, you want the answer automatic. That only comes from reps, so grab the link and start drilling today. Now let's turn to the companies themselves. Because New York regulates insurers just as tightly, an insurer becomes authorized or admitted by obtaining a certificate of authority from the superintendent. To earn one, it must meet minimum capital and surplus, an approved organizational form, and adequate lawfully invested reserves. That certificate is its license. An insurer without that certificate is unauthorized or non-admitted. Why care? Because an admitted insurer gives you New York solvency protection and the state guarantee corporation. A non-admitted one doesn't. Producers may place with a non-admitted insurer only through the narrow excess line mechanism, and only when coverage isn't available from admitted companies. Admission is just the start because the department supervises solvency continuously. Every insurer files an annual financial statement verified under oath due by March 1st, showing its condition as of the prior December 31st. It also examines domestic insurers on a recurring cycle and may examine any time for cause. This watch keeps promises trustworthy. One more piece of company oversight. New York reviews policy forms and for many lines rates to ensure they aren't unfair, ambiguous, or inadequate. Life and health policy forms must be filed with and approved by the superintendent before use. That file and approve requirement is exactly why the standard policy provisions you study feel so uniform. When someone breaks the rules, the superintendent has a graduated toolkit. It can investigate and examine, hold a hearing after proper notice, issue a cease and desist order, impose monetary penalties, suspend or revoke a license, and refer suspected crimes to the Frauds Bureau or prosecutors. The chosen tool always fits the severity of the violation. 2 penalty figures recur. Violations of the licensing article carry up to $500 per offense, capped at $2,500 in the aggregate. General violations run up to $1,000 per offense, and critically, enforcement always follows due process, notice and a hearing, and a licensee may seek judicial review of an adverse decision. For exam day, here's what I'd actually memorize from company regulation. The insurer's license is the certificate of authority. The annual statement is due March 1st. Licensing penalties are $500 per offense, $2,500 aggregate. General penalties $1,000 per offense. You don't need reserve math. Focus on the licenses, dates, and dollar caps. Let's clear up what confuses almost everyone. When a producer may charge a fee instead of a commission. A commission is paid by the insurer from the premium for selling a policy, the ordinary model, no special paperwork. A consultant's fee is different, paid by the client for advice separate from placing any policy. Because that fee comes straight from the client's pocket, the law demands protection. A fee for examining, advising on, or evaluating insurance is lawful only under a written memorandum, signed by the person charged, clearly stating the compensation with a copy kept at least 3 years. This applies to agents, brokers, and consultants alike. Can a producer charge a fee and earn a commission on the same deal? Yes, if done right. Say a broker wants a $300 analysis fee plus a commission on the policy placed. That's fine, so long as the fee sits in a signed memorandum and follows compensation disclosure rules. Undisclosed, it's a violation. As we enter the final stretch, remember that understanding these rules is only step one. Real mastery comes from applying them, and that's where those free practice questions become invaluable. They're completely free, built specifically for the New York Life Accident and Health exam, and they'll turn today's knowledge into test day confidence. Let's consolidate the special licenses which the exam mixes up. A resident, agent, or broker passes the exam and holds a 2-year license, completing 15 hours of continuing education every 2 years. A non-resident is licensed through reciprocity with their home state. A business entity can hold a license too, naming a responsible licensed individual. 2 more round it out. A temporary license lasts up to 15 months for a producer's death, disability, or military service, so the business can be serviced or sold, generally without new solicitation, and an adjuster is either independent on the insurer's side or public, where a public adjuster posts a $1,000 bond. Here's how to separate the confusable ones. A consultant advises for a fee and doesn't place coverage. An agent places coverage for a commission, and the fee always needs that signed memo kept 3 years. And keep the 15s apart. 15 months is a temporary license for a person. 15 days the termination notice. You might wonder why these rules come from New York, not Washington. 2 federal laws explain it. The McCarran-Ferguson Act of 1945 declared that regulating the business of insurance belongs to the states. That's why New York, not the federal government, writes the rules you're studying. State primacy traces straight back to that one statute. The second is the Gramm-Leach-Bliley Act of 1999. It modernized financial services and pushed states to adopt producer licensing, reciprocity, and consumer privacy protections. New York's reciprocity statute, it switched to the word producer, and Regulation 169 all put Gramm-Leach-Bliley into practice. So behind reciprocity and privacy sits a federal push. Let's do a rapid-fire pass on the most tested numbers. Report a criminal action within 30 days of your initial pretrial hearing. Not at conviction. Report an administrative action within 30 days of final disposition. The controlled business limit is 10% of your net commissions, and the temporary license, remember, runs up to 15 months. Now, the claim handling deadlines under Regulation 64, all in business days. Acknowledge a claim within 15 business days. Pay an agreed amount within 5 business days. Respond to a department claim inquiry within 10 business days. Then 2 retention figures. The fee memo kept 3 years and policy and claim records 6 years. Here's a subtle trap worth its own moment. Every Regulation 64 claim deadline is measured in business days, excluding weekends and legal holidays. But most other Domain 1 deadlines, the 30-day reporting rules and the 15 and 30-day termination rules, are calendar days. So if a claim question gives a deadline in calendar days, it's wrong. Let's bring it together because you covered a lot. We started with licensing, who qualifies, who's disqualified, and who needs no license at all. We covered the 3 kinds of agency authority, apparent authority, the big trap, then appointment and termination with those 30 and 15-day timelines, and the defamation immunity rewarding honesty. From there, we tackled the Article 24 unfair practices, sharpening that crucial line between unfair discrimination and illegal rebating. We covered market conduct exams, the 3 pillars of insurance fraud, and the opt-out versus opt-in privacy split. And we saw how New York admits and supervises insurers, disciplines violators, and governs consultant fees and special licenses. So before you go, grab those free practice questions from the link in the description. With the depth you've built today, plus focused practice on those questions, you'll walk into that exam room genuinely prepared. They're completely free and designed specifically for New York Life accident and health exam success. Put them to work. Here's your next step. Review these concepts once more, then practice until the answers feel automatic. You built real understanding today, not just memorized facts, and that carries you through the tricky questions. Believe in your preparation, stay consistent, and go earn that license. I'm rooting for you, and I know you can do this. That wraps up our study guide on insurance regulation. Now it's time to put everything into practice. Head over to the website where you'll find hundreds of free practice questions along with complete in-depth study guides covering everything we've talked about today. Simply click the link in the description below to get started right away, and don't wait too long. Good luck with your studying, and I'll see you in the next one. Subscribe so you don't miss our next video, and good luck on your New York Life accident and health exam.